Welcome to Case Law Minutes by litigationhelp.com, your public legal education provider. My name is Huizinga, and in this video we are going over the case of Kaplanis versus Kaplanis, which is a Court of Appeal case from 2005. But first we need the disclaimer. This presentation is for general legal information only. For advice specific to your case, please consult a lawyer. The facts of the Kaplanis case is as follows. There is one child of the marriage. At trial, the trial judge ordered joint custody. The order refers to joint custody, but the term custody has since been changed to decision-making authority and means the ability to make decisions regarding schooling, medical, religion, and activities. Anyhow, back to the case facts. The trial judge ordered joint custody as well. They ordered counseling for the parents to learn to better communicate and work together. The mother appealed this decision, arguing that the trial judge erred in two ways. The Court of Appeal released its ruling and agreed with the mother that the trial judge did indeed err. The Court of Appeal of Ontario overturned the trial judge's ruling and awarded sole custody to the mother. In their ruling, the Court of Appeal made several remarks. With respect to joint custody and the parties' ability to communicate, the Court of Appeal found at paragraph 11, the fact of one parent possesses an inability to communicate with the other parent does not in and of itself mean that joint custody cannot be considered. On the other hand, hoping that communication between the parties will improve once the litigation is over does not provide a sufficient basis for the making of an order of joint custody. There must be some evidence before the court that despite their differences, the parents are able to communicate effectively with one another. No matter how detailed the custody order that is made, gaps will inevitably occur. Unexpected situations arise, and the changing developmental needs of a child must be addressed on an ongoing basis. When, as here, the child is so young that she can hardly communicate her developmental needs, communication is even more important. In this case, there was no evidence of effective communication. The evidence was to the contrary. With respect to parental counseling, the Court of Appeal found at paragraph 14, it may certainly be desirable for parents to take counseling on how to better parent their child, and to hire a counselor or parenting coach to resolve disputes. The order provided by the trial judge was, however, problematic. The legislation does not specifically authorize the making of an order for parental counseling. And while some trial judges have held the court has inherent jurisdiction to make a counseling order, carrying out the order requires the cooperation of the parents. There was no evidence that the parties would be able to agree on whom to appoint. There was no agreed process for the appointment of a counselor in the event that they could not agree who should be their counselor. Nor was there any evidence that they were willing to submit their disputes to be decided by a counselor outside the court process envisioned under the Divorce Act and without recourse to it. You can get this case from canli.org using the link in the description below the video or the link displayed in the video. Thank you for taking the time to watch this video, and tune in to other videos from the most cited list of family law cases.